Who do we have here?
Mr. McCray, Your Honor.
All right. Good morning, Mr. McCray.
How you doing?
Mr. McCray, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On April 3rd, 2024, the officer was dispatched to an apartment in Harris County, Texas, in response to an assault call. The complainant is the defendant's daughter. The complainant is the defendant's daughter's boyfriend, and the complainant was staying with her daughter and when she got on the phone call from her boyfriend. The defendant got upset and said he was tired of this bitch's voice, referring to the complainant. The defendant got in the complainant's face and punched her in the lip, causing pain.
What? Did you notice that? This case just quickly got out of hand. We're talking about a father who allegedly knocked out a tooth by striking his daughter's boyfriend so hard. Losing a tooth does, in fact, count as assault causing bodily injury. Under the law, however, I have a question for you. Do you believe that family conflict should remain behind closed doors, or should it ever flow into criminal court like this?
Mr. McCray, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail. Do you understand? In fact, I'm going to send you right now for a drug test. I want to know what, if anything, is in your system. I'm also ordering you not to be in possession of weapons and not to have contact with the complaining witness in this case. Do you understand?
But they want to write an affidavit. Can they do that?
I don't answer questions, Mr. McCray. I'm telling you what the expectation of is while you are in this court. You can either abide by the expectation or you can, the other thing is going to happen. Do you understand? Are you high right now?
No.
Be careful. I'm sending you for a drug test. If you fail to go take the drug test, if you fail to come back, you know what's going to happen. Just take a seat for me and then we'll get you. I'm sending you for a drug and alcohol test right now. Do you understand? Take a seat for me, sir. Top of page 11. Sorry, I want to know how we're, come up, Miss Imam.
You just met, so we
Okay.
haven't had a chance to.
I'll give you a little bit of time, but
My understanding is procedurally what has happened is she was on a pretrial diversion.
correct.
Her previous lawyer has passed away.
Mhm.
The state has rescinded or terminated the pretrial diversion that she was on. I've had a chance to kind of go through a little bit of in the way of discovery. She wants to move forward and try to figure out what we're doing with the case, needs me to do that. By way of background, she works as a pharmacy technician at Walgreens, as a student in college. Quite a bit of mitigating stuff. I need to really have some time to dissect it all.
Is she using while she's on bond? Was that the issue?
Let me see, Judge. I'm not sure why Nathan.
Shatoria, tell me about Miss Imam, huh?
It looks like she had continuous violations on her device after being placed on a zero tolerance. She had a pattern of failing to report the visits. She failed to complete SOP.
This is when things start to get. A scram device is ordered by the judge. In essence, an ankle monitor that uses perspiration to check for alcohol. No excuses, no hiding. This maneuver has zero tolerance. Consider it. If you were in her position, would you rather risk going to risk going to jail for only one mistake, or take the device and prove yourself innocent?
Alcohol monitoring device. I don't see any. The violations on the device were skip tests.
And Judge, I think there was some times where there were some missed tests. I don't know that.
So I'll give you time.
Yes, Judge.
Okay. I'm putting a scram on your ankle now, so I know that you're not consuming alcohol. And if I find that you consume alcohol, or if I find that you're consuming illegal drugs, it's really, really not going to go well for you.
Yes, sir.
Do you understand?
Yes, sir.
Yes.
Does she have a Texas driver license?
Well, let me talk to me.
Just,
You run it, Judge.
Mhm.
Yes,
Looks
she
like it
does.
hasn't been run. Okay. You're running it? Okay.
so let's do this. I'd like her to get a scram today.
Yes.
I'm also going to send her for a drug test because I want to know what, if anything, is in her system. We'll sit you off 2 weeks for you guys to decide what you guys want to do. Okay, get what you need. Your case is 530 days old. It's time to decide what we're going to do. It looks like they've already kicked you out of the program. I don't know if they're going to relent and let you back in. I don't know, but I'm going to tell you now, let's just cross that bridge when we get there. But
What I would like is if in maybe 60 days or something like that, if things are going well on the Scram device, maybe come back in and revisit and get a.
I don't, well, no. I don't know if I'm going to keep the case open 60 days. It's 525 days. I mean, I'll give you some time,
I just
but
need to make sure all the
We
discoveries.
do have an offer in on this case as well.
what is
We put
it?
an offer, a time served.
Okay, so there's an offer. So when we come back, I'll give you 2 to 3 weeks, but when we come back, you need to either accept the plea bargain from the state or I'm going to set your case for trial. If I find that you're using or doing anything to violate the law while you're on bond, now I'm going to put you in jail. Do you understand?
Yes.
That's it. You're not allowed to drive unless you have liability insurance in your name. If you do not have car insurance, do not drive. Do you understand? Okay. So we'll give you 3 weeks,
Yes.
Mr. Garris. But at that time, when you come back,
Set it up. I will
either accept or if you're going to provide mitigating evidence to the state
try to get back in the program.
before that day, so we know,
I will do that in advance.
please.
Yes.
Okay, Ms. Simon. All
Thank you,
right,
Judge.
so I'm going to put the devices on her today. She gets a test today and all fees waived.
Thank you.
Judge, my apologies, I misunderstood. Could you please go over those conditions again for me?
I want to send her for a drug test now,
Yes, Judge.
and I'd like to put a scram on her ankle now today as well.
Yes, Judge.
Okay? We'll set the case. I'm sorry?
You want random UAs as well?
Well, no, I just want to know if she's clean now or not. And then in 3 weeks, this case is
Yes, Judge.
one way or the other.
Yes.
And then, okay,
Thank you, Judge.
all right, guys. Working. Good morning, Mr. Anderson. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present.
This is the heart of legal drama.
The legal drama revolves around this. Probable cause. The defense contends that a person should not be stopped for just weaving within a lane. They're also not incorrect. That is supported by Texas case law. However, the officer said there was swerving and that other people were in danger. The kicker is this. If you were a judge, would you follow the letter of the law or follow your instincts about whether a stop was warranted?
If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 8th, 2024, the officer conducted a traffic stop on the defendant's motor vehicle after observing it failed to maintain a single lane while traveling west on Jester Boulevard. The officer observed the defendant constantly veering out of the lane and going into the second lane. The officer observed the defendant to be the driver and sole occupant of the vehicle, and while speaking to the defendant, the officer observed a strong odor of an alcoholic beverage and bloodshot eyes. The defendant was struggling while exiting the car and was swaying back and forth while speaking to the officer. Standard field sobriety tests were performed, HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was read, but the defendant refused and a blood search warrant was drawn and executed.
Your Honor, may I make argument, Judge?
Sure.
Thank you, Judge. The sole reason for the stop in this case was failure to maintain a single lane. Most recent case law on this is Hardin v. State. And in that case, it overturned even Lemming. And they went as far to say is that failure to maintain a single lane is not probable cause for a stop.
Well, I get it, right? You have to dictate more than just saying failure to maintain.
Yeah.
You have to have provide
a danger to another vehicle. There's other vehicles around. This is on TC Jester Boulevard, a very sparse road at night. And this
So what were the indicative facts?
I'm opening the office.
Yes, Your Honor, we're looking at the office report.
I mean, obviously, we don't have any body cam, dash cam, so I'm not,
Well, right, but this is just a mere probable cause. I need enough of a statement from the officer in the DIMS saying how he justified pulling the car over in light of failure to maintain a single lane. The weaving statute.
Wait,
I mean, do you need a bit of time? If you want to reconvene in like maybe 30
Yes,
minutes.
Judge.
It's fine.
My offense report's not loading for some reason, so.
If we may have a little bit more time.
Mr. Saman, do you have somewhere else to go?
I have Fort Bend to go to. Can I go to Fort
Well,
Bend?
That's going to take hours. If you want to, yes, because you can always zoom in. I have Zoom for you.
I'll wait.
So perhaps maybe, 15 minutes, give them time to look at the OR.
Okay.
Just take a seat for me, Mr. Anderson. We'll come back. For now, we'll have you sign a reset.
Oh, no.
Okay. Hi, Counsel.
I've got Moises Serious.
What's the last name?
Moises.
What was the last? S.I. Okay.
Soon you know the one I'm talking about.
Say it again.
Somebody walking, black man walking.
Oh. Good morning, Mr. Sirius.
No.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 8th, 2024, the officer conducted a traffic stop on the defendant's vehicle at 1:05 a.m. after observing it drive at a westbound on Washington Avenue, following a vehicle in front of him too closely, and for having an expired registration. The defendant was the sole occupant of the vehicle and driver, and upon contact with the defendant, the officer observed a moderate odor of an alcoholic beverage, glossy eyes, and low and mumbling speech. The defendant admitted to drinking, and standard field sobriety tests were conducted. HGN was 6 out of 6, walk and turn 3 out of 8, and one leg stand was 1 out of 4. The DIC was read, but the defendant refused, and a blood warrant was signed and executed.
Okay. Mr. Sirius, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license, sir?
I do, yes.
Okay. Do you have valid liability insurance in your name?
No, it's not my vehicle.
Okay. If you don't have car insurance, then you're not allowed to drive. I'm making that a condition of your bond. If you want to drive to follow the Texas law, you must have a Texas driver license or a driver's license from another state, and you must have liability insurance in your name.
Yes,
If you don't have both, then no driving. I am ordering you also as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any illegal drugs, likewise, your bond will be revoked. You'll go to jail. Do you understand?
John.
You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Stone, and he will tell you when you have to come back to court. If he tells me he can't get a hold of you, you're playing games, I'm going to issue a warrant for your arrest.
John.
I'll have you go to Victoria, sign a reset. We'll have you get with your bond conditions with Felicia, and then you guys are free to go. All right, guys, thanks. It's fine.
Right this way. Next judge is page 2. Chavez, come on up.
Okay. Did you have a,
Yeah, arrangements. It's your Chavez.
okay.
You're good.
Good morning, Owen.
Every other weekend we go to, there's a small restaurant called Prima Pasta. They have a singer who wears a different blazer every time he comes in. How many
Does this look like
it? How many blazers do you, I guess.
Quite a bit. Good morning, Ms. Chestnut. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. Okay. On December 5th, 2024, the officer responded to a flock hit for a stolen license plate, and upon locating the motor vehicle, the officer conducted a traffic stop. Upon contact with the defendant, the driver of the vehicle, the officer detected an odor of an alcoholic beverage, slurred speech, and red glossy eyes. The officer confirmed the VIN was a match with the stolen vehicle hit on MDT, and the defendant admitted to drinking 2 drinks, one of which was a large margarita. Standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 0 out of 4. And the reason for one leg stand being so low is because the defendant walked instead of doing the one leg stand. The DIC was read but refused. Blood search warrant was drawn and executed.
All I see is just the DWI. That's it.
Yes, Your Honor, there was no charges filed, and I don't know the reason for that. We can look more into that, but.
It's not, okay, so any prior DWIs?
No, Your Honor.
Did you run or NCIC?
Yes, Your Honor.
Ms. Chestnut, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license, ma'am?
Yes, sir.
Have you run a license?
It's eligible, Your Honor.
I'm ordering you now as a condition of your bond not to drive any vehicle unless you have liability insurance as well.
I have
It's part of your bond conditions. I am also ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If we find that you're consuming alcohol or any kind of illegal drugs, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, Your Honor.
Okay. What do you do for a living, Ms. Chestnut?
I'm working at this time on Social Security.
Okay.
Yes, sir.
Did you want to apply for an appointed lawyer, ma'am?
Yes, sir.
Okay. Do you mind? You know what? Let me see if I have one on file. Hold on. I need you to fill out an application for me. I'll take a look at it to see whether you qualify or not. If you do, then we'll appoint your lawyer. So for now, I'm going to have you go to Victoria Center, reset. He's going to give you the application and then we'll have you take your seat in the jury box. Ma'am.
Okay.
Okay, please.
Craddock, Khalil, page 3.
Good morning, Mr. Craddock. Mr. Craddock, you're charged with theft. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Yes, Judge. One moment, it's loading right now. Okay. An officer was dispatched to a target in response to a theft. The officer made contact with the complainant, the loss prevention officer, who stated he observed the defendant come into the store and make a small purchase, leave, and then return and conceal merchandise in the shopping bags. The defendant then took the concealed merchandise and walked past all points of sale without paying. The total taken was $750.05.
And was he with anyone?
No, Your Honor.
All right, Mr. Craddock, I'm going to find that there's probable cause to go forward with the case. How old are you, sir? What do you do for a living?
I am currently waiting for a call to back so I can working.
Say that again.
I am waiting for a college to get back to me, but I'm currently working at Taco Bell.
So you graduated from high school? Okay. Did you want to apply for an appointed lawyer, sir?
Would it be okay if I ask my mom that?
Is your mom here? Sure, of course. Mom, come on up. Thank you so much for coming. Did you hear what happened?